Next, after Mr. Burnett, we'll hear from Michael Allan Wolfe, who is the Richard E. Nelson Chair in Local Government at the University of Florida, Levin College of Law, who received his degrees from Emory, his law degree from Georgetown, and master's and PhD degrees in history and American civilization from Harvard. Professor Wolfe is a prolific scholar and includes dozens of articles and numerous books, including The Zoning of America, Land Use Planning and the Environment, and most recently, The Supreme Court and the Environment, The Reluctant Protector.
Good afternoon. I'd like to thank Nancy and the law school and the center for inviting me here to your beautiful state to spend 15 minutes talking about this subject. I didn't realize that the event would take place in this room named after Justice George Sutherland, who happens to be somebody I know a good deal about. The reason I know a good deal about him is he wrote the opinion in Euclid v. Ambler, which is the case that established the legitimacy of zoning, saying that zoning was not unconstitutional in 1926. Of course, that's very relevant to what we're talking about today, because this, of course, is a form of land use regulation, public and private land use regulation. The tax folks here also know that Justice Sutherland also wrote one of the landmark tax opinions in Supreme Court history, Gregory versus Helvering, which established the principle, the only principle that I remember from my tax course, which is that you're not supposed to elevate form over substance. And so I guess it's fitting that we're in Justice Sutherland's room to talk about this issue. Here are two titles. I figure I'd give you your money's worth. Here are two titles for what I'm going to talk about. One, I'm going to talk about some of the unintended consequences of the fact that we refer to these things as conservation easements, which I would prefer that we called them conservation hybrids, or at least I think that's a more accurate description of what they are in reality, and something that I will call the nomenclature problem. So, you know, we're all familiar with the term a rose is a rose is a rose. Well, in this case, a rose is not a rose. And this is not unusual in the field of real property. That is, the notion that the fact that we call something by a name does not necessarily mean it means the same thing. So not every rose is alike, and not every easement is alike. This is not an unusual phenomenon in the area of real property law. Now, why am I concerned about this? Well, I will tell you that there is a personal reason why I'm concerned about this issue of what I will call term creep. And that is that I'm very possessive of the field of real property law, because I have been bestowed the responsibility of sort of keeping track of developments in real property law, as I am the general editor of the leading treatise in the area, and I can say that because I didn't write it. I have the responsibility for keeping it up to date, which is Powell on real property. So it is really from my own personal, this is a personally motivated talk I'm going to give you today, my concern about the nomenclature problem and what I call term creep. Now, let me give you some examples of what I call term creep. Trespass is a common term found in real property law. But trespass is not just a term found in real property law. We have criminal trespass, right? So there's a crime that we call trespass. And it appears historically that out of the crime of trespass came something that we call trespass to real property, which is still a very important concept in the practice of real property law today. We also have trespass to personal property. So now there are three different kinds, three distinct different forms of action, two in tort, criminal law, and yet they all share the same name of trespass. And we even have something today called cyber trespass, which developed in the 1990s. So we talk about people interfering with other rights in their web pages and the like, and that is referred to as cyber trespass. This is a quintessential example of term creep. When we say the word trespass, it means too many things, too many contrary things. And we have a set of legal principles attached to each of these four kinds that unfortunately will creep from one area to the other. Here's another example, nuisance. The word nuisance, you know, we've made a nuisance out of the word nuisance in law. Nuisance just means harm. It comes from the French, it just means harm. We have private nuisance, which is the unreasonable interference with the use and enjoyment of somebody else's real property, typically your neighbor's property. That's a tort. We have public nuisance. Unfortunately, still, that is a crime. That's an activity that poses serious to the general community. It's not neighbor versus neighbor. It's everybody versus that polluting factor. And if that's not bad enough, term creep in this area has given rise to the fact that you can recover damages for a public nuisance. As I tell my students, it would be as if we combine the two, his criminal trial for murder and the civil trial for deprivation of civil rights for which the plaintiffs recovered damages. To allow the recovery of special damages is the same thing. It's allowing a cash recovery for what in essence is a crime. Another example of term creep. We have another thing, another aspect of real property law, which is becoming today in our times, moving into foreclosure, and that is adverse possession. Now, adverse possession is the type of possession that really needs to be exercised like other possessions. Adverse possession of real property, so that one can, in a sense, become the legal owner of the property by stealing it from someone else, merely by the passage of time, and the expiration of the statute of limitations. We also developed a notion of adverse possession of personal property. This is absurd. This is an absurdity. If I lose my watch or somebody steals my watch, how are they supposed to make open and notorious use of my watch? Look at my watch. You can't see my watch when it's under here. You see that? Now you see it, now you don't. Okay? Or a work of art. If a work of art is stolen, works of art are stolen all the time. How am I supposed to make open and notorious use of a work of art? I want to put it on my wall. No one's ever going to see it. Yet, until fairly recently, everybody talked about, this is a legitimate notion of the adverse possession of personal property. Yet another example of term creep. And of course, they're both forms of what we call prescription. And now courts get mixed up and talk about adverse possession in the prescription context. Prescription refers to easements. Adverse possession refers to time. But you can't trust courts to get it right. And I could cite you off the record recent examples of courts using the terms improperly. King talked about the restatements from the American Law Institute. Well, there is a restatement that is relevant to conservation easements, and it's the third restatement of servitudes, which is a fairly, I often say it's a restatement, because the idea behind the restatement of servitudes is to get rid of the distinctions between the traditional forms of servitudes. So far, that idea, unifying servitudes, has not caught on with the courts. That's why it's not really restating what has already happened, a classical restatement. It really is pre-stating, sort of wishful thinking. We'd like to get rid of the distinctions between these kinds of servitudes. What are they? Real covenants that run with the land. Easements, which are both appurtenant and in gross. Equitable servitudes, which are real covenants that cannot be enforced in a law court, so they're enforced in an equity court. Much easier to enforce, but different remedies. Profits, the right to take something off somebody else's property. And of course, licenses, which are not interests in law. They are contractual rights that often have to do with the use of property. My favorite example is a case that I urge everybody to look up, Patel. It's a tax court case in which somebody attempted to take a tax deduction because they bought a house in Vienna, Virginia to tear it down. They notified the local fire department. They gave the house on the property to the fire department so they could use it to teach how to put out a fire. So they destroyed the home that they wanted to tear down anyway to build a new home. had the, excuse my French, chutzpah to seek a tax. And the United States court pointed out that, you know what, this is not a partial real estate interest. A license is a contractual interest. Thank goodness they didn't rely on the third restatement, which really we shouldn't have at all. Okay. So I would prefer that we refer to these things now as conservation hybrids, because that's what they are. They are like hybrids. Because, and this is now quoting from the work of the Uniform Commissioners, a conservation easement is valid even though it's not a pertinent. Pertinent is an easement term. It can be valid even if it has been assigned to the holder. Well, this is relevant to licenses, assignable, and to in-gross easements, which classically were not assignable. So despite these traditional rules, conservation hybrids or easements can be assignable. They are permissible even though they're of a that has not been recognized traditionally at common. And that would refer to all of the servitudes that I've. There are certain kinds of that are not, certain kinds of covenants, and so on down the line. That is not going to prevent this conservation hybrid from being enforceable. And even though it imposes a negative burden, it will be enforceable. That again is a reference to traditional rules limiting the categories of negative easements. Here's another hybrid. The conservation hybrid is valid even though it opposes an affirmative obligation. That again might violate traditional rules of covenants and in some cases easements as well. And the benefit does not touch or concern real property. That's a very strong covenant law and equitable servitude law. So even if it doesn't touch and concern real property, this thing, this hybrid that we call a conservation easement, can be enforceable. And finally, it's enforceable even in the absence of privity, which of course is a real covenant term. All right. I commend the commissioners for coming up with what has turned out to be one of the most successful uniform laws in the real property area, covering all states, much like right cover all states. It's a very successful legislative effort to change common law real property rules for, in my opinion, for the good. So I'm not critical of the term. Now, not every state which has a conservation statute uses the uniform law. About 20 states. And almost all of those 20 states use the term conservation easement. Many states do not use the term conservation easement. These are some of the terms that are used instead of the term conservation easement. My favorites are conservation, servitudes, and land use easement. Actually, land use easement, I'm kidding. I don't like either one of those, okay? I don't like the reference to the word servitudes, and I don't like a reference to the word easement. Okay, I have a modest proposal. I'm going to rename them. Take cov from covenant, ease from easement, and L from license, and you end up with a Caviezel. You might recognize that's Jim Caviezel. No, that is not my modest proposal. My modest proposal is to call them conservation. So I guess we would say, now UCIA, Uniform Conservation Easement, now UCHA, something like that. All right. Now, why should we care? Why do I care? Why should we care about the terminology? Well, because there are a few problem areas that we've talked about already today that are only problem areas because we view them as easements. For example, the doctrine of cypre does not apply to an easement. And courts are having trouble with this issue because they're saying this is an easement, we cannot allow this restriction to stand, and we can't use the cypre doctrine to keep it going. The same thing is true with merger. If it's an easement, the doctrine of merger can be used to terminate it. Well, it's not an easement. It's a special creature. It's a hybrid. It's not an easement. And then the remedies that can be used also confuses the courts. These confuse the courts. All right. There's also what I call the boomerang phenomenon. And this is a quotation from a California case from the 90s in which there is a cyber trespass case, and the court cited, in a real property trespass case, cited the cyber trespass case to come to the wrong conclusion. The notion of trespass went out to cyber law and came back and negatively affected real property law. And that could happen with conservation easements as well. I could see a conservation easement case which said there's no reason to have touching and concerning and privity, and then we could have a covenant case in that same jurisdiction and said, you know what, touching and concern, privity, they're not required. We're going to get rid of them based on precedent. That's what I call the boomerang phenomenon. Okay. Luckily, we don't really have to come up with a new name. The Internal Revenue Code tail, in many instances, but not in all instances, really does wag this conservation preservation dog. Notice how the termination the years. In 1976, there were specific references to leases, options to purchase, or easements as partial interest in property for conservation purposes, along with remainder. Then it became entire interest, remainder, restriction, and eventually perpetual conservation restriction. See that? That is a functional definition of what we're talking about. A functional definition. That is the way to define something unique and sui generis. To define it in functional terms, not to use terms that are otherwise familiar. Okay, why do we want to avoid the term creep? Why do we want to use the right name, an accurate name to describe these? Number one, you avoid the term creep and boomerangs. Two, you associate the legislative heritage of the term with the public interest. Okay? That's really, we invented these things, or he invented these things because of the overwhelming public interest. And third, we will disconnect these hybrids from traditional rules that if we follow these rules, will make it more difficult in the future to enforce perpetual easements in circumstances such as easements that are affected, the terms that are affected by climate change. Okay. See, the rose is a rose after all. Thank you.